Contract. Introduction to the law of contract. Contract. An agreement enforceable by law is contract. Agreement. Every promise and every set of promises forming the consideration for each other is an agreement. Promise. When the person to whom the proposal is made signifies his assent to it, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Proposal. When one person signifies to another his willingness to do or to abstain from doing anything with a review to obtaining the assent of that order to such act or absence, he is said to be make a proposal. The person making proposal is the promiser, and the person accepting the proposal is called the promiser. Contract is equal to agreement plus enforceability. Contract. Offer plus acceptance plus legal obligation. Essential of a valid contract: offer and acceptance, legal relationship, competency of parties, consideration, free consent, lawful object, not declared as void, certainty, possibility of performance, legal formalities. Classification of contract. Express contracts are contracts created by word, verbally or in writing. Implied contract, a contract created by conduct of a person or the circumstances of particular cases. Quasi contract, which is also called constructive contract, an obligation imposed by law. As per enforceability, valid contract, an agreement which is enforceable by law. Void agreements and agreements which is enforceable by law, which is not enforceable by law, is called void agreement. Void contract. Uh, a contract which ceases the enforceability of law becomes a void contract when it ceases to be enforceable. Voidable contract, an agreement which is enforceable by law at the option of aggrieved part. Illegal agreement, an agreement of object of which is illegal. Enforceable technical agreements, an agreement which is otherwise valid but due to some lacking such as writing etc. Remains enforceable as per performance. Executed contract, when both parties have performed their respective promises, is called executory contract, a contract in which something remains to be done. Proposal or offer, when one person signifies to another his willingness to do or to abstain from doing anything with the view of obtaining the assent of that other to such act or absence, is said to be proposal. Essential of proposal, essential of an offer. Two persons, the persons making the proposal is called offerer, the persons which accept the offer is offeree. Certain and definite contract intentions, an offer must be made with the intention to create a contract. Then fourth one is communication. Offer must be communicated to offeree. Communication is complete when it becomes to a knowledge of offeree. If offer is made by post, the communication will complete when letter reaches offeree. Offer can be made by words spoken or written through conduct of person. Objective of consent. Offer must be made with the view of obtain the consent of the other person. Conditional. Offer may be subject to some condition. It is also direction of offeree to either accept or reject it. Uh, Conditional offer lapse with when condition is not accepted. Negative confirmation. An offer cannot be in the form of negative confirmation. For example, if it's not accepted within a specific time, then it will presume to have been accepted. Invitation of an offer. An intention of a person to invite others with the view to enter into agreement. Purpose of such invitation is to create or circulate information of his red lines to the transitional. Such intentions are not considered offer. Communication of a special conditions. If there are special terms in an offer, they must be specifically communicated to offeree. Types of offer: specific offer, general offer, cross offers. If an offer is made to definite or particular person, specific group of persons, such offer can be accepted only by the definite person or that person of that specific group of persons. General offer. If an offer is made to the world or public, then it is said to be a general offer. Such offer can be accepted by any person. Contract is made with the person who, having the knowledge of offer, comes forward and acts according to the conditions of the offer. Cross offer. If two parties ignorant of each other offer made similar offer to each other, crossover are not equal to the acceptance. Standing, opening, continuing offer, tender. Tender. What is a tender? If an offer is of ongoing nature, a contract is entered only when the person signifies his acceptance on the basis of tender. Acceptance. When the person to whom the proposal is made signifies his assent to it, the proposal is said to be accepted. Absolute and unconditional. An offer should be accepted without any condition. If any condition is imposed on acceptance, then it would be called counteroffer. Communication. Acceptance may be completed when it communicated to the offer.